cannot now support this bill.
Jonathan Young.
I move the question be now put.
Eugenie Sage.
New Zealanders love and want to protect the places in our country which are habitat for our distinctive and unique and precious wildlife and quite dramatic landscapes. They don't want miners to have a go first, and that's why 50,000 people marched down Queen Street. So I'm pleased to stand here for the Green Party to speak for nature and for those wild places that so many New Zealanders treasure, to speak for a smart and sustainable economic plan and to oppose this bill. Because the bill represents a profound change in the way conservation lands are managed and the way in which mining applications are considered. And it's a major change in our whole philosophy about the place of conservation in New Zealand. And as Damien O'Connor noted, when those 1991 changes came in with the Crown Minerals Act, the Conservation Act in 1987, there was a recognition that as manager of conservation lands, holding them in trust for all New Zealanders, the Minister of Conservation had a right to say no to mining applications in the same way that private landowners, through the Crown Minerals Act in 1991, were also given the right to say no. This bill makes a major change to that because it puts the Minister of Energy as a decision maker alongside the Minister of Conservation for any applications to prospect and mine on conservation land. And by doing that, it's failing to give adequate weight to the Crown's other statutory responsibilities in the Conservation Act. But we know that this government doesn't care about conservation because it's cut the funding to the department, it's axed 140 jobs, and it's proposing new legislation to further change the Conservation Act, potentially to weaken it, so that it can extract greater value from conservation land. And this is what the bill is all about, having conservation land opened up for mining rather than for the preservation and protection of the species and landscapes that we value. Mr Chair, I'd like to talk specifically about clauses 31 and 32 and the changes they make to section 61, because it's there that we've got these changes that put the Minister of Energy inside alongside the Minister of Conservation as a joint decision maker. And there was a small change in Select Committee to restrict this to Tier 1 applications for exploration and mining. But given that the threshold between Tier 1 and Tier 2 is how much the mining company estimates it will spend on its work program for exploration permits, and what it estimates will be the annual production and royalty for mining permits, I imagine that most applicants will make sure that their estimated expenditure exceeds what the $1.25 million threshold. And one of the very troubling things in this clause, so it's clause 31, 1AA, is that it's giving this joint decision-making power not only for new applications, but also potentially makes the law retrospective, because the joint decision-making power applies to a variation to an existing access arrangement if the purpose is to allow significant exploration or mining activities. So that means, as I read it, that any existing mining or exploration permit that's been granted can potentially be significantly expanded, and the Minister of Energy will have a role in that decision rather than just the Minister of Conservation. So it's potentially allowing existing applications on conservation land, which the Minister may have decided to restrict to smaller areas with less impact, to actually significantly expand. And this whole joint decision-making power implies that the Minister of Conservation, as advised by the Department, cannot be trusted and is not competent to assess the effects of mining applications and decide them. And as submitters noted, and I'd like to quote Linda Conning when she said, "It is an unwarranted increase in ministerial power where there is no obligation to promote the purpose of conservation, and it is an undesirable precedent for joint ministerial responsibility to enable interference in other portfolios." We don't see the Minister of Conservation able to make decisions alongside the Minister of Fisheries on the total allowable commercial catch, regardless of the fact that fishing has a lot of impact on our wildlife and on marine biodiversity. So why should we have the Minister of Energy making decisions on conservation land? Are we going to see, under the new changes to conservation legislation that have been highlighted in the briefing to the incoming Minister, the Minister of Tourism having a joint role in decisions about tourism concession applications? Mr Chair.
Eugenie Sage.
Thank you, Mr Chair. So it is showing the double standard that the government is applying to the exploitation of our public protected lands that's at the heart of this bill. And it's interesting, Mr Chair, when National amended the RMA in 2009 to remove the Minister of Conservation's role in relation to restricted coastal activities, such as big reclamations or major dredging, that was because it was seen to be inefficient to have two decision makers, the Regional Council and the Minister. Yet here, when we can encourage exploitation of our conservation lands, the National Government is quite happy to have joint decision making. And, Mr Chair, there is nothing in the legislation which highlights what happens when there is a difference of view between the Minister of Conservation and the Minister of Energy. And as Damien O'Connor noted, there will be significant pressure applied to the Minister of Conservation to do what the Minister of Moby wants, who's actually pulling all the strings here. So we will have the Minister, who's supposed to be the guardian of our protected conservation lands, not having control over what happens on those lands. And as Mr Finlayson noted, words are important. The Conservation Act is about the preservation and protection of natural resources. That is a completely different statutory test to the one in this bill about the promotion of mining. So where you get the Minister of Energy involved, it will be overriding protection and preservation, overriding the fact that in 1987 the Conservation Act highlighted the views of all New Zealanders that these landscapes should be protected for present and future generations so that we could protect their intrinsic values, we could enjoy those lands, recreate in those areas, enjoy wilderness. This bill actually cuts across that by opening up conservation estate for much greater exploitation. The other way it does that is by the change in the decision-making criteria and the introduction of a new test of direct net economic benefits of the application. That will have to be weighed alongside the impacts of the application on conservation values, the impacts of the application on recreational use, but that economic benefits, as we all know, it's much easier to quantify jobs, much harder to quantify intrinsic values, so you will get the jobs that are potentially created, short-term jobs, often by people coming from offshore, trumping intrinsic values, trumping conservation values. So there is a fundamental change in this bill which undermines the way in which conservation has been valued since 1987 through the establishment of the Department of Conservation and the protection of the conservation estate. And that's because this government has a very empty economic agenda which is all about the exploitation of nature. It's not about sustainable economic growth. It's all about short-term dollars, setting aside areas that have been protected just to allow companies like Bathurst to come in. And that is another noxious part of the bill, the transitional provisions, which mean that the Bathurst application will potentially benefit from this joint decision-making, and where the ministers, in answer to questions, have already flagged that they support this Bathurst application, we potentially see those protected conservation lands on the Denniston Plateau with those distinctive ecosystems being opened up for large-scale mining, open-cast mining, which would destroy those pygmy pines, those quite special landscapes, just to provide a few short-term jobs for our Perth, Australian-based mining company. This bill, Mr Chair, is bad law because it reneges on the protection of conservation values, and the Green Party will oppose it.
Mr Chair.
Andrew Little.
Chairman, pleased to take a call on the committee stage of the Crown Minerals Permitting Crown Land Bill.